Welcome, everyone. For those who don't know, my name is Andrew Brand. I'm the director of the Morad Center here at Villanova Law School. A background in representing players, working for a team, and now in academia as well as media. This is a unique opportunity for us to have one of the co-lead counsels for the NFL concussion litigation, which reached an historic settlement about 3 weeks ago. And let's give a warm welcome to distinguished alumnus from Villanova Law School, Saul Weiss. We want to get into it, and we have our time together to talk about the settlement in any way that you can or are able to. I understand this is ongoing. But maybe the first thing we should know is tell us how you got into this, how you got into representing former football players and their families in this litigation against the NFL.
For years, one of my partners, Ned Ehrlich, who you know, had represented injured athletes for compensation claims. And Ned was on the NFLPA panel of approved lawyers to represent these gentlemen when they were hurt. Not just football, hockey, baseball, basketball, soccer. And I guess it was 3 years ago that my partner in Arizona, Larry Coben, and I were speaking, and Larry has done a lot of helmet cases for high school and college kids who have had terrible injuries playing football or riding a motorcycle, when it might be, and we started talking about the incidence of concussions in the NFL, and that's how it started. And we were fortunate to have some really good players like Jim McMahon, who wanted to see this done right. And we did it.
Okay, let's fast forward. So we were here together here at this school in March talking about litigation in our symposium out there in the Commons. Since then, 2 weeks after that, I attended the motion to dismiss by the NFL. And from that point on, at least from our perspective, we expected some kind of decision from Judge Brody in July, but she decided not to have a decision and to push you parties together towards what turned out into a settlement. So take us inside that in what way you can in terms of what happened from April until August.
The issue was preemption, and most of you who are in law school probably know federal preemption is a doctrine that says that you can't use a state court law that would conflict with a federal law. In this particular case, there's a collective bargaining agreement, and so the Labor Manager Relations Act has provisions. And one of the provisions are that you can't bring a lawsuit that has to do with any term in the collective bargaining agreement. So the NFL's position was dismiss the lawsuit and force these guys into arbitration or grievances. We thought that was wrong. It was a very contentious issue. You were at the hearing. Both sides argued it very well. And it's one of those things in litigation that you're damned if you do, damned if you don't, because whoever would have won before Judge Brody, that decision would have gone to the Court of Appeals. That would take a couple of years. And then it would end up in the Supreme Court of the United States. And so you all know in the last term, the Supreme Court heard 9 preemptive decisions. In 7 of the cases, they found that the case was preempted. So the plaintiffs lost those cases, lost the right to be in court. That process could have taken 4 or 5 years, and what was ever left of the case would then go forward. And there's a whole bunch of other defenses that the NFL had. And so it was inconsistent with our goal of trying to get people paid who were sick and get them paid quickly. So we decided to talk.
And how did those talks go initially, and then did they speed up right in front of the season?
I don't think the season had anything to do with it. What did have to do with it was Judge Brody, who from the time that she formed the NDL, which is multi-district litigation, where every federal judge has to send the case that's assigned to them to Judge Brody. And her goal was to try to get a case resolved because she knew there were cutting-edge issues, like preemption. So she instructed lead counsel on both sides to begin to talk. We talked for well over a year. When things didn't go as she planned, she brought in a mediator, a retired judge, federal judge, Lane Phillips, and those things heated up and we got a deal.
Was mediation in a room, in a physical space where you got together and it was triangulated with the NFL side on one side, the plaintiffs on the other, the judge, or was it much more by
Good question.
phone, by conference call? How was it?
There were a lot of different ways and times we met, so it wasn't confined to one space or one time.
Okay.
What went on, we really can't talk about. Judge Brody does not want us to speak about what actually occurred in the mediations. So I can't, or I would.
Okay.
She's the judge.
And I ask you this: how do you feel about it? What was your initial reaction to the settlement?
I was elated. I'm very happy for the players because we achieved what I said we were going to want to do in March. That is, for the guys who are really hurt and their families, get them paid. And for the other players who needed testing and don't have insurance, we set up an independent way in which they can get tested for any neurological problems they might have.
How will that work? Will that be kind of a panel where someone presents themselves and this is my issues and how much do I get? It sounds very complicated.
It's really not. We're going to set up a nationwide network of qualified physicians. There'll be neuropsychologists and neurologists. And hopefully within 50 miles of where any player lives, they will go and they will get a battery of tests that our experts designed. And they will be graded on those tests. And based on those tests, they will see a neurologist who will then render an opinion as to whether they have any cognitive deficits or injuries. And it's all objective. It's all based on science.
Will players that join the lawsuit that have no current symptoms be entitled to compensation?
If they become injured in the future, for example, if someone is 35 years old now and is relatively stable, but they develop dementia, Alzheimer's disease, Parkinson's disease, ALS, they will get a payment when they develop it. So the injury portion stays open for 65 years. So people can come in as soon as it's set up and approved by the court and no appeals for the next 65 years and get paid.
Will the money run out?
I don't think so. I'm pretty sure it's not. We hired economists and actuaries and medical scientists, and we are very comfortable that there's enough money in that fund to last 65 years.
Okay. So the settlement sweeps in all retired NFL players, is that correct?
About
Whether they were part of the lawsuit or not?
correct. 19,000 or so retired players.
Each one will have an opportunity.
Every single one has an opportunity to participate either in baseline testing or if they're injured and they meet the diagnosis, receive a payment.
Okay. And for that, the NFL, and as I'm sure you're aware, for a lot of your lawsuits that you settle, the defendant has no admission of liability.
I've never settled a case with a defendant in 41 years where the defendant's admitted liability. The issue is not liability, the issue is getting compensation to the people who need it.
What do you say to the people that say the NFL got off easy here? And you know you've seen that out there. I have, and I've dealt with those questions as well.
First of all, $764 million is a lot of money. Second of all, we have enough money to pay the players who are hurt for 65 years and to have this free medical care for those who need to be tested. And if they come up abnormal in the testing, they're going to get medical care paid for by this fund in the future. So it's not about $2 billion or $4 billion or $10 billion. It's about having the right amount of money to do the deal now and not wait 5 or 10 years for appeals to run out.
And when do you think these players will see money? Ballpark.
Assuming there are no objections at the fairness hearing, which will not be until the spring of 2014. By the end of 2014 or early 2015, they'll be getting payments.
And the status you just mentioned. So when is the next, and clarify if you will, Judge Brody, the presiding judge, has to, for lack of a better word, sanction this settlement, bless it, approve
He
it?
has to do a couple of things. We're going to put a motion in front of her and ask her, based on the papers, to preliminarily say to the public, this looks good. You can send a notice out, I'll approve it, and all 19,000 people who could be affected will receive a notice of proposed settlement and the date for a final hearing, an evidentiary hearing. At that hearing, which will be 90 or 120 days after the notice goes out, that's when all the evidence will be brought out about the soundness of the funds, why there's enough money, the science that went in behind the definitions for the injuries, things like that.
And will that be the forum where players that object to the settlement will be heard?
Correct.
What do you anticipate that to be like? Do you anticipate the numbers in the several or the tens or hundreds to object to the settlement at that hearing?
I really believe when people understand and see the actual documents, there'll be very few unhappy people.
And that's the question I'm getting a lot, I'm sure you are. Can they opt out of the settlement and bring their own lawsuits against the NFL?
Yes, they can. And the NFL has the right to say if too many of them do so, the deal's off.
Deal buster.
Correct.
Likelihood of that?
Not very likely.
Remote.
I say remote.
Okay.
You have to understand, if someone opts out, they're back into the court system, they're going to face preemption.
Right.
They're going to face statute of limitations. They're going to have to prove that the injury they have didn't occur whether they're playing football in high school or college.
Right.
Not an easy task.
And that's what we talked about here, the issue of causation.
Correct.
But the causation issue, you were confident about the case,
Still out.
knowing the causation issues.
Absolutely.
Why? Realizing that in every deposition they would say, didn't you play high school football? Didn't you play pee-wee football? Didn't you fall on the ice one year? Those kind of questions.
Our theory, which is being backed by the evolving science, is that there are links to the types of injuries you get playing, head injuries playing football, to ALS. For example, I believe the studies show that people who have had concussions are 4 times to 6 times greater likely to get ALS than someone in the general population. In many courts, that's sufficient evidence to make out a case of we call general causation. Now, your doctor is going to have to specifically say why, in your case, the injuries you sustained caused your ALS. That's a different burden. For Parkinson's disease, there's also an increased risk. Alzheimer's, not many people get Alzheimer's in their 50s or 60s, or I guess late 50s, 40s. There is a greater percentage of football players who've been concussed who have that than those in the general population. That's the kind of evidence that we think will be helpful. But then again, a jury could say no.
Right. And in the master complaint, there were a lot of allegations of the NFL beyond causation. There were negligence and misrepresentation and fraud and concealment.
Correct.
Those go away, obviously, with a settlement.
Well, the settlement is people get paid.
Right.
And everyone goes to the business. And you have to understand the purpose of settlement is not to look back, is to look forward. Resolve the claims. Let people move forward.
Whatever the NFL had or didn't have over the years, I assume if it went forward, you would be trying to get those documents.
Correct. But this was not about getting documents. This was to get people paid and compensated and tested. It's a different agenda.
So tell us, when you told a specific client, a bunch of clients about this, the reaction, especially those that have been suffering?
Overwhelmingly, our clients are very supportive of the settlement and very grateful. You have to understand, a lot of these players had a very glamorous life. They were pro athletes. They can't work. So they don't have money like they had when they were playing football. And a lot of these guys, very short careers also. So they didn't save a lot of money. Their families are destitute. I mean destitute. And I've talked to a lot of wives and the kids. It's horrible. These guys have had mood changes. They're depressed. They don't know what hit them. There are days when Jim McMahon's girlfriend, Lori, has to plug in his GPS so he gets where he needs to go when he drives. That's not good. We have other players. Some of them are in homes, and they're 50 years old. They're in nursing homes. And yet the families have to go on. So for those people, we had to get them money as quickly as possible, and good money. And the settlement will provide real good money for those people. It will help their lives and their families, and that's what it's all about. Not about a smoking gun document that the NFL hid some evidence.
If this went forward, you mentioned in your opening comments 2, 3, 4, 5, 6, 8, 10 years
Correct.
of litigation.
That's right. And a lot of these players who are on the fringe will just lose out. You'll have some more players committing suicide, which is a horrible thing. Ray Eastling was alive when we brought this lawsuit. He had a horrible 10 years before he committed suicide. They were hanging on every day. What's going on? Can I be helped? They need money. They need some validation that this was not in vain, that they did nothing wrong. It's real important to understand that. That's the human component.
And you think ballpark they'll get some compensation by this time next year or earlier?
No, I said the end of 2014 or the beginning of 2015 without any objectors, because objectors will take it to the Third Circuit. And nothing can be distributed until we have a final order.
Can current and I guess future players sue the NFL on this issue?
Not on this issue, because we only represent retired players. The current players are protected by the union, and the union represents them. Now, whether there will be changes downstream in the CBA, I don't know. And before I forget, one of the benefits that we have in this settlement is none of the benefits under the collective bargaining agreement are abrogated by the settlement. So they're separately different. So if someone's entitled to it called Mackey benefits or 88 benefits or Neurocog benefit under the settlement, under the collective bargaining, they get that, in addition to what they get in this deal. And the last collective bargaining agreement had a clause that if you wanted to get the neuro benefit, you had to waive your right to sue. That's no longer valid. They can do both. That's an important piece in the settlement.
And I did not know that. Speaking of the CBA, the collective bargaining agreement done between the NFL and the NFLPA, the latter group, they've been what I think is strangely silent through all this. They represent the players. They had a one-sentence kind of bland statement about the settlement. Where is the union in this, and were they involved at all in your settlement discussions or dealing with the
Well,
plaintiffs?
the NFLPA was not involved in the litigation at all. As I say, they represent the present players, and the agreement is between the union and the teams.
The CBA.
Yes. There's a tension because any benefit that the collective bargaining agreement gives to a retired player comes out of the pocket of a current player. So the union's not really keen necessarily on going 100% behind retired players, and that's the tension, and we only represent retired players.
Were they involved at all?
No, not at all.
Not their attorneys? No.
Not at all.
How many players were you working with your firm?
We have about 350 players
In the litigation?
in the litigation that we have signed contracts with.
And as I said, I imagine the symptoms range from serious, even to the point of suicide, to just interested in, is it monitoring in the future with no
Correct.
current symptoms?
We have some asymptomatic players, some who do not have insurance or don't have insurance that covers the kind of testing they need. We're very happy that they can get this testing, which is going to cost about $3,000 a full battery of tests. And again, it's an independent organization. It's not run by the NFL. It's not run by the players' union. It's run by the settlement. With no input from the union and very little input from the NFL.
So again, a player that has no symptoms now and develops cognitive symptoms, dementia, whatever it is, 10, 20, even 30 years from now, will be entitled to benefits.
They will get a benefit, and the benefit will be increased by a cost of living factor from year to year to keep them on parity with the people who get payments now.
What's your feeling about the NFL after all this? I know you're a football fan.
I will say the NFL stepped up to the plate and did the right thing, which is a good thing. This lawsuit, as we talked about in March, has had a lot of good effects in hockey, in college soccer, women's field hockey, lacrosse, any sport where you can have a concussion. I think the game will be safer for all the participants, whether high school, college, semi-pro, whatever it is. And in fact, on the expressway now, there's a big sign from Rothman Institute
Saw that.
about concussions. So it raised an awareness in the public, which is a good thing.
And I will say this, in dealing with talk about football, all I hear about is how these suspensions and increased fines for these hits, and they shouldn't enforce them this way because they're just trying to get the guy down and they don't know where to hit, they don't know to hit low or hit high. It's had an impact. The question I have, Saul, is it going to fade with the settlement? As we get further away from the settlement, will the NFL's vigilance about hits to the head fade?
I certainly hope not, and I don't think it will. You look at last year and this year, the NFL has cracked down.
Yeah.
It's not just the NFL. It's all sports. Look at some of the Phillies that got hurt this year with concussions. Dominic Brown, they kept them out, 10 days? That would never happen in the past. There's a sea change, and it's a good sea change. It doesn't mean it's the end of football. It's a great thing. Football will still be around, and it'll be exciting, but they're going to teach kids at a young age how to tackle properly and not tackle with your head.
So that leads to the question I get all the time. Would you let your kids play football? Mine are vertically challenged, so that's not an issue with me. But your kids are probably older, but...
My kids are older. I have 4 daughters and 1 son. They're all grown. It'd be their choice. I'll tell you this, Kevin Turner is a good example. Kevin made his oldest kid wait till he was in high school before he could play football. That was a tough thing for Kevin. Those who may remember Kevin Turner, he played with the Eagles. Kevin has ALS. It's sad to see Kevin deteriorate, He's able to walk. The use of his hands is getting worse. He needs full-time caretaker. And Kevin's having a harder time speaking. Yet he's out there every day supporting the settlement.
He is.
So there are a lot of pro people. I understand that, having a senior moment, the quarterback for the New England Patriots,
Tom Brady.
Tom Brady's father said he wouldn't let his kids play football anymore. Kurt Warner won't let his kids play football. There's a number of people who out there won't let their kids play football. But I think when they have safer rules and their kids are taught how to tackle differently, people will relent and they'll play.
During the lawsuit, did you hear people would say to me, well, don't these guys realize you hit each other in the head when you play football?
Sure, but just because you hit in the head doesn't mean you're going to be injured. The problem is when you get injured, you can't go back into the game.
Right.
And that was the culture that had to change, and that culture is changing. They used to make these guys go back in. They give them some smelling salts, go back in. Well, that's really bad. And Bob Cantu and Ann McKee and Chris Nowinski up in Boston, they've done a great job. And they've really demonstrated how people have to get back to baseline before they can resume sports. And that'll save a lot of injuries later on in life.
The problem I always say, and you can comment on this, is that we often have to protect players from themselves. And that's the worst part. Because we have this culture of playing through. And I'm sure a lot of you guys out there that play sports, you just want to play. You just don't want to be taken out of the game. So I dealt with players who bombed their baseline testing so that when they were concussed, they wouldn't look different. And in football, especially in the NFL, it's a business. So you're out for 2 games with a concussion, you may never play again. The whole Alex Smith, who's here tonight,
Correct.
what happened to him last year with the 49ers, he did the right thing, never got his job back.
Yeah, but he's playing now for the Kansas City Chiefs.
Yeah.
He's a starting quarterback, still making a lot of money, and he preserved his brain.
Right.
So he did the right thing.
You hope more do.
That's the point.
You hope more do, but a lot of players are looking at Alex Smith and saying what I said. He sat out, and he never got his job back.
You know,
that's an unfortunate thing that's happens.
if people know the risks and they want to take them, that's on them. This whole lawsuit was that people didn't know the risks. They didn't realize there were long-term effects to their mental health when you got concussed or subconcussed and went back in and played. They didn't know it. Look, people play sports, they get orthopedic injuries. Those injuries limit their ability to play, so they don't play. It should be the same for mental injuries. You should be limited and not be able to play. The fact that you can run doesn't mean you should run. And I saw a couple shows on either 60 Minutes or one of the Dateline, girls, high school girls playing soccer, heading the soccer ball. And they showed girls who can no longer read with these lights. They have to be in darkness because they've had head injury from playing soccer. So their grades are down, they're mentally impaired, and they have to change the way in which they're going to live. They didn't know that before. I don't see many soccer teams letting the girls or even young kids who are not developed head a ball. Not a smart thing. And can be avoided. Yet you can still play soccer, enjoy the game. Now, when you're a 25-year-old male and you have well-developed neck muscles and you know that you hit a ball from your waist forward, that's a different thing. But when kids are too young, their bodies aren't mature, they can't do it.
And who's protecting them?
We have to protect them. we had that, the NFL had that role with these guys. They assumed the safety of the players. And if they were candid and honest about what their committees in 1994 through 1999 really found out about closed-head injuries, they might be in a different position, but they didn't. Instead, they chose to deny any causal connection between ALS or Parkinson's or dementia and playing football in the NFL.
Beyond the lawsuit, and this may be out of your arena, do you feel the NFL has admitted to that link?
Yes.
Not necessarily ALS, but a link between playing football and future neurological damage.
What I can tell you is, I think it was in 2009, Roger Goodell testified in front of Congress and denied there was any causal connection.
Right.
And they have since changed their position. So I do believe that the NFL is becoming more proactive. The NFL is doing a research program with GE on scans for about $60 million. The NFLPA is spending $100 million in a 5-year program at Harvard to study NTBI. All good things.
On the legal front, we're in a law school. Where does it go from here in terms of, there's an NCAA litigation that's active.
There is. Correct.
Will your settlement have any impact on that, in your opinion?
Maybe tangentially, but not directly. It's a whole different circumstance. As you know, as you pointed out, the thrust of our case against the NFL was the intentional withholding of the information they developed from 94 forward about these injuries. That was a big component of our case. The second thing is the NFL is a singular, it's an entity comprised of 32 teams. The NCAA has I don't know how many thousands of participating colleges. So I think it's a whole different setup.
Do you give the chance to that litigation on the plaintiff's side a fighting chance?
I'm not even going to go there.
Okay. I won't make you handicap that. And then, of course, high schools and athletic associations and amateur associations.
There's been a big change. And I can tell you that in the area high schools, the private schools, they are really monitoring their kids. If a kid has a closed-head injury, that kid is not returning
That's true.
to the practice field. Will not let them participate. I know this firsthand because I have a trainer who happens to see it happen for school. And they're very, very careful about the kids. And they can get some resistance from the parents, but they won't let them play.
You know, I have a 6th grader that just went through impact testing.
It's a good thing.
It is a good thing. We have a little bit of time for some questions. I know people were wondering if they could ask. If you have a question, you can raise your hand. Yes, sir. Hey, Greg.
For the settlement down the road for retirees that their symptoms start showing up down the road, I guess, what kind of causation will they have to prove?
None.
So,
The beauty of the settlement is there's no proof of causation. So whether your injury occurred either from high school or college, that's not an issue. Just if you meet the injury definition, you get paid. Unless you've had a car wreck where you've had a brain injury, then you get a very large deduction, which is only reasonable.
does it matter if they played, I guess, most recently, if they're currently playing the AFL or just for the Canadian football league?
Only the time that they played in the NFL counts. So if you played in the NFL for 5 seasons, you get a full payment, depending on your age. And a season is defined as not actually playing all season, but just being in a roster for 1 game, active roster. So anybody who has 5 years in, there's no deduction penalty. If you played 4 years, you get 80%. If you play 3 years, you get 60%. It goes down that way. On a practice squad, you get a half a season credit.
So again, to clarify, you come in front of a medical decision maker, you're not going to be asked the questions we talked about. What about playing high school? What about falling on the ice? What about a bike accident back in the...
Absolutely correct. So what happens in the monetary award fund is a little different. There's an administrator, and you will deliver to the administrator your records. They'll look to see confirmation for the injury, the date that you were diagnosed with that injury, and then they'll see how many years you played, and you'll get a tentative award. It's that simple. Not very complex. And there will be medical advisors around to assist the decision makers if they need it. But like I said, the definition for ALS is pretty standard. For Parkinson's disease, it's pretty standard. Alzheimer's disease is pretty standard. So it's not a lot of subjectivity. It's mostly objective looking at records. That's a good question.
And you're confident that the fund for that is not the $765 million,
$675 million. Yes, I am.
will be more than enough for 65 years?
Correct.
Another question. Yes.
How does the compensation for the families of players that have died work?
Well, if you died from ALS, you will get the ALS benefit at the age of your diagnosis. If you committed suicide and your brain was autopsy and you had CTE, the highest payment is $4 million, and it will go down after a certain age. It's graded. And again, you have to play 5 years. So that's how it's done. And I believe Alzheimer's is $3.5 million at the highest payment. I think Parkinson's is $3 million, around that area. ALS is the highest at $5 million. It's a very horrible disease with a lot of complications. And by the way, in the settlement, we have a program that we're doing with the government to resolve liens. So those of you who know, when you have a recovery, while the recovery may be tax-free, if you received any medical care from the government or a state, they get the money back. And if you have private insurance, they may get some of the money back too. So we're having a program to resolve those for a lot less than the cost of the care, which is another benefit for the players. Yes?
You've mentioned a lot of these players have committed suicide because of the difficulties they faced after having concussions. You've mentioned that there's medical care for players who develop ALS, Parkinson's, Alzheimer's. Is there anything in the settlement devoted to mental health care for these players who are suffering every day?
Yes. If somebody goes into the baseline assessment program and their tests come out abnormal, they have a problem, but the problem is not great enough to get them paid on the injury side, they're going to get a medical benefit card, or medical benefit will allow them to get additional care paid for by the settlement. That's not part of the 675. That's part of the baseline assessment program. So yes, they will get care by a qualified physician near where they live. Yes?
You said current players now aren't covered, but once current players retire now and they're not under the auspices of the union anymore, are they covered, or are they sort of in no man's land?
They'll be in no man's land because the cutoff date for retired players will be the effective date of the settlement, which is the date that the court approves the deal.
The August 30th date or the date in the future?
The date in the future. Yes?
Many of the players have already incurred expenses at their own, for their own sake, to get diagnosed, etc. Is there any retroactive payment for those?
No, but if they would get a grid award, we're going to work with their insurance company to make sure that the insurance company doesn't take up a fair amount of that. So that's called resolving liens. That's part of our program. Good question.
How do you and your team of attorneys manage the logistics of what's obviously a really extraordinarily complex litigation?
Okay, meaning what?
The flow of documents coming in, the expert witnesses.
Well, we, like any other group, we're organized. We give assignments out to various people. And we collectively look at proposed experts. We have spoken to 4 or 5 world-class neurologists. We have used we use Grant Iverson, who is worldwide in his scope of neuropsychology. He's working with the Department of Defense on how to treat soldiers to come back who have brain injuries from IEDs and everything else. And other people like Grant, and they helped us understand the science and understand the mechanics of how to get the deal done. That'll all come out in the Ferris hearing.
Yes, did I read in the settlement that your fees, collectively your attorney fees, are handled by the NFL?
Correct. That's outside the settlement. So when
Plaintiffs do not pay.
they do not pay for the work we did to get the settlement done. Some of the players do have contracts with lawyers, and they'll be honored in some fashion. But the NFL is paying on top of that money. So they are paying more than $764.
And who sets, this is probably a sensitive question, who sets your fee?
It'll be approved by Judge Brody. When we come to a resolution, I can assure you we're still talking the NFL, and we'll get it done at a fair price.
There will be lawyers.
Well, they have an incentive too, and they wanted to get this done, and they didn't want that pool to be diluted by a lot of attorneys for us, which it won't be. Other than those who have contracts with their lawyers, and they'll be worked out. In other words, some players have signed up with lawyers, and lawyers filed lawsuits for them. There are other players who don't have a lawyer, and they're going to get the same benefit. Any other questions? Good, yeah.
You said this, this is a multi-district litigation, and you talked about all the different attorneys that were involved. How difficult was it to get everybody on the same page once the settlement talks started heating up as to what the final number would be?
Well, there are 2 questions. Let me take it back a step. In any multi-district litigation, the court sets out a decking committee, a steering committee. Judge Brody appointed those people. We had regular meetings, which work was discussed and other things were discussed. And there was a separate group that negotiated the settlement. And because Judge Brody had a gag order on, we couldn't even tell the members of our committee what was going on. When, I guess, 2 days or 3 days before the settlement, we got permission to talk to the steering committee. They know what you know. Nobody on the steering committees have received the actual documents that were signed. They should be produced when we file for approval with Judge Brody.
I know you can't talk about those negotiations, but the parties were your group of lead counsel and the NFL owners. I thought I saw Christopher Seeger talk about dealing with Jerry Jones, perhaps. And were the owners the actual negotiators, or were there?
I don't know how much I'm going to get into that, but
Whatever you can say, or not.
what I will say is that the NFL itself had a committee of owners who interfaced with the NFL lawyers, and that's about as far as I'm going to go with that. What Chris may have said about Jerry Jones, He's entitled to his own opinion. Yeah.
At both the high school and Pee Wee level, you mentioned that they're trying to change the culture to minimize the types of hits that are going on. A lot of coaches are not knowledgeable on the proper techniques of tackling. Is the NFL, as what you're aware of, making that movement, or is it going to be a third party that's going to try to change?
I can answer that. I think there are all these heads-up movements around where the NFL is reaching out, a lot of grassroots campaigns where they go into high schools with local stars. They just did one in Carolina where Cam Newton showed up, and that's a real emphasis for the NFL to teach proper tackling techniques. That's not to say it's going to infiltrate all these high schools.
Almost every game you watch on TV now will have a little PSA about that. The NFL is out there with present and past players trying to educate as many people as possible on safe techniques. You see them tackling this way now, landing on I guess it's a mat to show them the right way in which to tackle. It'll be effective. Another good question. Any other questions over here? We have a few minutes left.
I would just like to add that I think what they miss in that heads-up program is the education about the second hit for the young children. They still go in not understanding that getting hit again. And I think that the proper techniques is fabulous, but being from a football family and multiple plays, it's the trying to go back in and please someone when you're a younger child and not understanding that immediate second hit. And I see no advertisement or no education about that, even in the schools with the coaches.
Well, I hope schools become more outspoken and more informed. There's been a lot of publicity about this case. It's made people more aware, and I hope it filters down.
I just encourage you to use your influence.
I'd like to do that.
It's a great point, and I think the NFL is the beacon that everyone looks up to. And like we talked about with Alex Smith, who's ironically here tonight, the guys have to stop playing through. And it's not on the coaches. It's really on the team medical staff and management to separate that from coaching decisions. And I think it's definitely being done better than it was, but it's not all the way there, of course. Star players are going to be encouraged to play. You just got to make sure they are out the time they need to be out. There are no mandatory timeout for concussion. So you will see guys play a week later. There's nothing that says if you have a concussion, you can't play the next game. But they advance through sport-specific training, running on the treadmill, and then, of course, to doing football actions. And we saw it last year here with Vic and McCoy. And I think that is a good thing. I think in the past, we didn't have that. Now we have independent neurologists as well.
On the sidelines, which is a good thing.
It's a very good thing.
Well, the point I would like to make to all of you who are in law school, that whether you do litigation or you do contract work or transactional work, whatever you do, you have to remember you have a client. And the most important thing you can take away from this hour is that we kept the ball on the client side. It wasn't about the lawyers. You didn't see a lot of us in the news. It was all about the retired players and their story and difficulties they had. And our whole focus was to get the job done as fast as possible. So when people say to me, well, you only got $764 million, I said, I'd rather have that today than $1.5 million 10 years down the road. So it's really about getting what you need to do for your client. If you can take that away as you graduate law school, that's a good point to remember. Any other questions about the laws or anything? How the courts operate? You can answer those questions if you have them.
I'll volunteer you to stay up here a few more minutes.
Sure.
But thanks so much. This is a fascinating hour. I appreciate everyone coming, and let's give a